The concern that big money is having an outsized influence on Australian politics prompted the Labor Party to promise reform around the laws that govern donations and disclosure. But negotiations have been taking a long time, and the government is running out of time left in Parliament to introduce these laws and get them through. It really is crunch point. The Special Minister of State, Don Farrell, is expected to reveal the legislation in the next 2 sitting weeks of Parliament. But there's still a lot to work out. There's questions about the legality, questions of the democratic principles behind them, and of course, a lot of politics to negotiate. I'm Melissa Clarke on Ngunnawal Country here at Parliament House in Canberra, filling in for David Spears. This is ABC Insiders on Background. The Centre for Public Integrity has been tracking the big money in Australian politics, and its research director, Dr. Catherine Williams, joins me for the podcast. Catherine, thanks for being with me.
Thanks for having me, Melissa.
So, Catherine, to start off with, can you give me a sense of what sort of influence big money is having on the electoral system at the moment?
It's a great question, Melissa. It's really difficult to determine precisely what influence it is having, but certainly we know that big donors and big donating industry, so I'm talking about the gambling industry, I'm talking about the pharmaceutical and healthcare industry, about the resources industry, and big donors within them. Often what we see in their behaviour is that they distribute their donations more or less on a 50-50 division between the two major parties. And this is very different from the behaviour we see by other donors, which looks like clearly ideologically driven donating behaviour. When we see big industries and big donors donating more or less 50% to both major political forces, it looks a lot like attempts to get access. And that really concerns us because that undermines democracy and it undermines people's trust in democracy, which at this time in particular, we have to be so vigilant to protect.
And I gather we've had quite an explosion in the amount of money that's being spent in election campaigns as well. That seems to have grown a lot in the last 10, 15 years.
That's absolutely right. It's really difficult to estimate precisely how much is being spent on elections because the Australian Electoral Commission disclosures record total payments made by parties and candidates rather than specifically amounts expended on elections. But we do estimate that as best we can, and it absolutely appears that those amounts are increasing really substantially.
Okay, so this is part of what's been behind the Labor Party's decision to be willing to tackle reforms in this area. It's also prompted by a lot of calls from crossbenchers and independents wanting to see more transparency in the system. So we know the government has gone away and been working on new reforms that would limit donations in the size that they can come, caps on expenditure, and also improvements to that disclosure. So let's go through each of those one by one. Maybe if we start with the caps first. So a cap on campaign spending is one area we know the government is likely to propose. It's not clear if that will be a national level cap or an electorate level cap and precisely how it would work. But we know the discussion has been about trying to make sure that we're not seeing spending of more than $1 million per electorate in a campaign. Is that sort of cap something that would prevent big money from flooding into an electorate and having undue influence?
Certainly expenditure caps are something that at the Centre for Public Integrity we've advocated for a really long time to respond to this problem of wealth having an undue influence on our democracy. And the level at which those caps are set is a really complex question. Certainly we do want to see both in electorate and national level caps put in place. This is what we see in the kind of best designed expenditure cap systems that exist in Australia already, and we hope that that will be emulated at the Commonwealth level. The Joint Standing Committee on Electoral Matters, in its report into the 2022 election, identified the need to put in place expenditure caps for precisely the reason that you said, but the settings have to be right. And we now are waiting with bated breath to see what has been put in place by the government in this bill, as well as what sort of consultation process is going to follow the expected short release of the bill.
Let's come back to that consultation process because I think we'll need to unpick that. But let's stay on the idea of let's say an electorate-based cap. I know Kate Chaney, one of the independents who came in at the last election, has been very clear in saying she's worried about the idea of having electorate-level cap, saying, well, what if we manage to fundraise, $10,000 from a couple of, 10,000 people, each give $100, or you get $10,000 from 100 people, and you're saying you can't necessarily spend all of that if there's a cap in place. She is arguing that that's a sign of good democracy if a candidate can raise a lot of money to help an independent challenge a big party. Does putting a spending cap on potentially make it harder for outsiders to break into the party system?
It's a complex question. The settings for caps, we have to get them as right as possible. And Kate Chaney's concerns are absolutely valid concerns. We need to try, in the design of caps, to account for what we know are the incumbency advantages. We would be concerned about any expenditure cap or donation cap proposal that did not do that. But if the system can do those things, then caps are a really important part of the solution to the problem of the influence of money in politics. Just because you can raise $1 million or more doesn't mean that you should be able to spend it. It's not necessarily more democratic that a person who can spend more is the person who wins the seat, and expenditure caps respond to that problem.
Yeah, there's definitely the principal question. There's also a legal question too here, right? The High Court's previously looked at limitations on donations and found that giving money to a political party or to a political cause is part of the implied right to political expression. So can we expect that there might be High Court challenges to however this comes out, should it actually get through Parliament?
I would think it's almost inevitable that there will be High Court challenges to these reforms. And this is one of the reasons that what we hope has happened is that the government, in designing them, has obtained independent expert advice about the level at which the caps need to be set. This is a fundamental question in any constitutional challenge on this point, because the High Court, in dealing with a challenge on the basis of the implied freedom of political communication, will be looking at the evidence that the Parliament had before it in imposing any burden. It's not that you cannot burden the implied freedom of political communication. Certainly you can. That was upheld by the High Court, for example, in its 2015 McCloy decision relating to the New South Wales political donation ban for property developers. But there has to be evidence to justify it, and we'll be waiting to see what evidence the government has to justify the level at which its caps, if they exist in this this reform proposal that we expect shortly, are there.
So we've been talking about the cap on campaign expenditure, but there's also the cap on the amount that can be donated. The government's indicated that's something that it is looking at to limit how much any individual or business or organisation can potentially spend. So these questions of democratic principles and the legality of them, that applies to caps on both expenditure and on donation amounts, I take it.
Yes, that's absolutely right. And it was in the context of a ban on donations by property developers that the High Court considered this point in 2015. And the validity of that ban was upheld. And this is why what we would expect is that if there is evidence, there must be evidence before the Parliament. If it burdens this implied freedom, it is likely that the legislation would be able to withstand constitutional challenge, but it absolutely depends on there being sufficient evidence to justify it.
I know the government is certainly worried about the likes of Clive Palmer, who's been a big donor, one of the biggest donors we've seen, who has great intentions to continue to work in the political space and keep donating. So I'm sure they will certainly be worried, given he has a strong track record of being willing to go to court to make his case. But let's move on to the disclosure part of this reform. At the moment, any donation that is more than $16,000 $15,900, I think, is the current threshold. Is that right?
That's
we think
right.
the government's
Index for
looking
this
at
financial
lowering
year.
it.
That's right. Yes.
Yeah, so that's quite a lot of money. And the government has agreed, and as has all of the parties under the committee report that you mentioned earlier, that it should be lower than that. What would be a good level to have the disclosure threshold set at?
So we'd say that the disclosure threshold should be set at $1,000. This would bring the Commonwealth into line with other jurisdictions around the country. There shouldn't be anything difficult about disclosing donations above that amount, provided, of course, that in time what happens is that, for example, the AEC could be resourced to set up a portal of some kind that facilitates this process, particularly for smaller parties and for independents. But there shouldn't be anything difficult other than those technological considerations that we think can be dealt with around disclosing donations of above $1,000. Like, one of the consequences we know at the moment of the high disclosure threshold is that we've got what's sometimes referred to as hidden money or dark money, which in essence is money in the system which is of unknown provenance, amounting to now about $1.7 billion since 1998-99. Now, part of that is a result of this high disclosure threshold. And it just can't be the case that so much money is in our system and voters not have visibility of where it's coming from.
I think that's an interesting one too, because at the moment we often don't see these figures until 12, 18 months after an election sometimes. Should a time frame for quicker disclosure be part of this reform too?
Real-time disclosure absolutely needs to be part of these reforms. When we talk about real-time disclosure, what it means varies depending on what jurisdiction you're talking about. So we want to get really to as close to real-time disclosure as possible. At the moment in Victoria, for example, that means 3 weeks post-donation most of the year. In Queensland, it means a week most of the time, but within 24 hours during an election period. I think that's a really excellent innovation, a reduction in the disclosure period during an election. That's of real value to voters, but we absolutely need to do much, much better than the current situation where, as you said, up to 19 months can elapse between a donation being made and it becoming public knowledge. We'd really like to see moving towards a week, ideally, between a donation being made and disclosure of that.
I want to ask you about third parties, because I know this has been something that's been discussed in the negotiations between the government, the opposition and the minor parties in talking about this reform and how they're captured when it comes to dealing with caps and disclosing donations. How do we deal currently with unions or charities or other political groups who are spending money in political campaigns but aren't necessarily supporting a particular candidate or a party directly?
So currently, third parties are regulated really only in respect of disclosure requirements. So we have third parties and then we have significant third parties, which are the same sorts of entities that are spending more than $250,000 in a relevant period. And some of them are spending a lot of money, and they absolutely must be part of any cap system that we expect to have the purpose that you put caps in place for. Otherwise, money will simply flow to them and from them instead of to the other participants in the system. And we don't want to see that happen.
Yeah, so you don't want a candidate to reach a cap in their spending and then, for example, have an environmental NGO suddenly start to have political ads about exactly what they're campaigning for, but not for them, and it becomes a proxy system, for example.
That's absolutely right. The regulation needs to be designed in such a way that that's avoided.
All right. Now, I want to ask you about the South Australian reforms that they've been proposing, because they have tried to move towards a system where you would get rid of donations altogether and have a fully publicly funded election process. What do you make of that approach and how the South Australian government has gone about trying to introduce this reform?
So I would note at the outset that it would be fully publicly funded or almost fully publicly funded for sitting members, but new entrants would still have the ability to raise donations up to a $5,000 cap from a particular individual or entity. So when this bill banning donations was released back in June, we were one of a number of expert stakeholder groups who were highly critical of what was being proposed. Following the response that the government had to that bill, we were involved in a very constructive consultation process that saw the government do what we hope has been done at the federal level, and that is establish an independent panel to provide it with advice in respect of how to do this in a way that is not impermissibly burdening the implied freedom of political communication. And as a consequence of that process, really substantial improvements have been made to that bill. So, for example, when it was initially released, there was no third-party expenditure cap. There is now. There was no statutory review clause. There is now. There was no policy development funding. There is now. And a raft of other significant improvements have been made to it. There is, in our view, still a need to justify the level at which administrative expenditure has been set. It's our understanding that at the moment there is an independent audit process going on in South Australia to look at what is actually required for the two major parties, the Labor Party and the Liberal Party, to run their operations. And we understand that the results of that audit will be tabled in the House of Assembly when the bill ends up there in the near future. And that'll be a really important moment to see whether the level of expenditure on administration, which is coming from taxpayers under the bill, is justified, or if it isn't. And if it isn't, we'd really be urging the government and the parliament to address that fact.
It's interesting that consultation process after releasing the details of the legislation has been so important, because it looks like what we're coming up to at the Commonwealth level is the government releasing its legislation and then trying very quickly to get it passed before Parliament rises for the end of the year and potentially before we get to an election. So there might not be the same kind of consultation process this time around. And in fact, it does put a bit of a question mark over whether or not they'll be able to get it through or not. How imperative is it to get it through versus making sure you've got enough time to get all these details right?
We wouldn't want to see it get through Parliament as quickly as possible. We don't think that that's what's in the public interest here. We would like to see any bill be released as a draft and that there be proper consultation and proper scrutiny, because what we've seen in South Australia and what we've seen in respect of many other bills over the term of this Parliament is that genuine consultation results in really meaningful improvement. We don't get the best outcome for democracy when a bill is rammed through Parliament, say because it has major party support, for example. That isn't what we want to see here, and we're really calling on the government to ensure that there is a genuine process of consultation, and that if deficiencies of the reform proposal are identified in the course of that those things are remedied so that we can end up with something that is actually going to have a beneficial impact on democracy. And if it proves that the time left now in this term does not permit that to happen, I think we'd have to be thinking really carefully about whether what's in the best interest of democracy is that the non-complex and non-contentious changes, that is those around transparency, the reduced disclosure threshold, the real-time disclosure, and the broadened definition of gift get prioritised and passed, and the more complex ones wait until such time as there can be genuine consultation, genuine scrutiny.
I think we're definitely going to find out in a couple of weeks which way that's heading, and noting, of course, that any changes now aren't going to be in place in times for the 2025 election. This would be all for the following one. Look, Dr. Catherine Williams, thank you for taking us through a very complex area, and we'll wait and see what happens over the next couple of weeks.
Thanks so much for having me.
Thanks for joining us on the Insiders on Background podcast. Do send us through your feedback. You can reach us at insiders@abc.net. indepth.com.au. We love getting your feedback, so please send us through any of your thoughts or ideas for future podcasts as well. We'll have Insiders on Sunday with Patricia Carvelis standing in for David Spears. Thanks for being with us.
You're making us all feel very excited about being here.